Okay, good evening, students. We'll talk about reviews for test one. We'll try to go through it pretty quickly. And if you have additional questions, feel free to interject either on the topic we're going to be talking about, or if at the end, I'll be happy to stay on and address additional questions. What I'm going to be talking about in the review are the things that I think are important for you to know for the test. Hint, hint. But if you have additional questions just about general stuff after, you're more than happy to ask me. So let's start off with talking about, and don't write this down yet. I'll tell you when it's important for you to write down, but I want you to understand this concept. So you might recall that we have different sources of law. So we'll look different areas to find out what the law is. And one might be statutes that either a state legislative body or a federal legislative body passes laws, which become statutes. A second might be regulatory issues. So for like example, the EPA or Department of Commerce or anything that's an executive body, they can publish rules, regulatory rules. So that's a second source. But then the third source are published cases. And you saw some in the text about where you find cases, etc. But cases, the judges can do a couple of things. For example, they can comment about, oh, there's this statute, and this is how we, the judges, interpret the statute. They can look at the regulations that we just talked about, a regulatory body, and say, this is how I interpret the regulations passed by the EPA. Or in some instances, there might not be a specific law on the books or, from the regulations or from the state statutes or federal statutes. That might be judge-made law. They might say, well, there's never been a real decision on this or a legislation on this. So as a matter of law in this state, blah, 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 blah. That's known as common law. Okay. So when you look under judges, what a judge is issuing, he has to look at the precedent. What have other judges of a superior court said? And then he has to follow that common law. Now, here's the important part to remember. That you ran across a Latin term called stare decisis, which my Latin is poor, so that may or may not be the right pronunciation, but stare decisis, which literally means to stand on decided cases. And just please remember that when a judge is ruling on something, he must follow stare decisis. In other words, he must follow prior judge-made law, prior common law. Okay, so you have to, in other words, the judge has to follow precedents. And we can unpack that and waste an hour of your time, but we're not going to. So just the concept I want you to remember is even a judge, even if there's not a statute or there's been interpretation of a statute, a judge has to respect prior law in most instances. You just can't make up new law. There's a lot of exceptions, but that's the general concept I want you to remember. Next, and again, I'll give you the red flag when it's time to think, to pay attention to the specific topic. In general, you've read about defamation, to defame someone. Now, there are two subtopics within defamation, one being libel and one being slander. Easy way to remember this is slander is usually said. So remember that, not alliteration, but anyway, the mnemonic, that's a mnemonic device. So remember slander by said, and then libel is something that's written. You'll have to remember that for the test. But I do want you to remember what are the defenses to a defamation claim. Again, I want you to remember what the defenses are to a defamation claim. In other words, you get sued for defamation. What defenses can you raise and say, wait a minute. For example, if, Alyssa says, Kevin's an old, fat, bald guy. Well, it might not be nice to say, but it sure as hell's true. So truth, for example, If I sued her for defamation, truth is a defense. She can simply go to the judge and say, well, it's true. And she would win the lawsuit. So that was the specific thing to remember. Let's go back to a general concept. And we're going to come back to this later on, but let's cover it now. So keep in mind that when, let's say that you are going to sue someone, you just can't say, I sue you. You have to come up with a cause of action or a remedy. Different judges call them different things, but a theory, a legal theory of why I'm suing you or why you're suing me. And so, for example, Abigail's going to, I'm going to sue her for defamation. Well, I have to come up with the elements of what I have to prove. Okay. And again, this is general concepts, not remember for the test, but I want you to learn these and understand. So she might have to prove that it was, hurtful to me and blah, 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 blah. And it was not true, but there's 3 or 4 things that she would have to prove. Then I can just prove my defenses. So if Abigail doesn't prove all 4 of these, there might be 5 under defamation, I don't remember, but however many they are, if I fail to prove any one of these, she wins the whole case. So causes of action are the plaintiff's going to bring, and then defenses that you're going to come, you have to prove the elements. Where do you find those elements? Again, this is just general knowledge. You can find them in the statute that guides this case. But often you go to there's literally online jury instructions, federal jury instructions if it's in federal court, state jury instructions if it's in state court, and then there'll be online either civil or criminal depending on what type of case it is. So if you ever get involved in a lawsuit, just look them up. They're free, they're online. Depending on the state you're in, we would just say Oklahoma Uniform Jury Instructions, and we would just pull them up. And if somebody sued you for negligence, you can literally look up this jury instruction, find out what they must prove. Okay, now let's move on to our third specific test topic I'd like you to know. You may recall when a judge is looking at a contract. So Alyssa and I are in a lawsuit over a contract. I rented her an apartment in Tahlequah to go to NSU, and it was just a hellhole. It had rats and, And she rightly moves, but I sue her. You didn't pay the rent. Well, the issue in front of a judge, you may recall, on any contract, whether it's a lease, a car purchase, your credit card statement. So any contract, when we're involved, Alyssa and I are involved in this lawsuit, the judge generally looks only at the contract to interpret it. So Alyssa would say, hey, wait a minute, there were other problems. So you look outside this evidence. Well, please be relatively familiar with when a judge can look at something other than just the contract. You'll find this as the parole evidence rule, which is really an unfortunate name because it has nothing to do with criminal law. It has to do with contracts. Awful name. They should change it. Some people call it the Four Corners rule. But just remember the reasons a judge might be able to look outside the contract and look at others. For example, if the contract I gave Alyssa to lease this apartment had an ambiguous term, in other words, just on its face, it's like, boy, that's not clear what it is, then obviously the judge would have to have testimony from Alyssa and from me, in other words, something outside the contract, to determine what the intent was in the contract. Or if it's a specific housing term, he might have to have a contractor testify. What does this mean in your industry? So once again, please be familiar with, there's not that many reasons a judge can look outside of a contract for evidence, known as the parole evidence rule. Next. You may recall, this is general, then I'm going to get specific. You may recall we have the executive branch, or excuse me, the legislative branch, and they're going to enact statutes, whether it's state or federal. They'll come up with laws, statutes. Then the executive branch, and I'm forgetting regulatory or other law now. Well, this is just as an example. The executive branch, i.e. the president, signs it or vetoes it. Let's say he signs it. Well, yes, we have a law, but what do you call it when judges review the law, when someone brings a lawsuit to determine whether it's valid, it's constitutional, etc.? Well, it's pretty easy to remember that that's called judicial review. That's a specific term I want you to remember, judicial review. Okay. All right. We also talked about some jurisdiction issues. Jurisdiction is just a legal fancy term for authority. Brooke, does she have authority to go out and write tickets when someone makes her mad when she's driving? No, she doesn't have the jurisdiction to do that. Well, similarly to courts can only hear things or listen to cases that are within their jurisdiction. So they'll consider various things like subject matter jurisdiction. I haven't got to the specific one yet, so don't stress. But in other words, can that court hear the subject matter that's before them? Bankruptcy court is not going to hear a divorce. They're not authorized to do that. Likewise, a domestic family relations court isn't going to hear a contract case. Likewise, a civil court who would hear a contract case isn't going to hear a criminal case. That would be a criminal judge. So that's the jurisdictional issue on subject matter jurisdiction. Then we also have the concept of jurisdiction over the person. In other words, Amanda lives in California. I try to sue her here. She's never had contact with California, with Oklahoma. She's never done anything in Oklahoma. She's et cetera, et cetera, et cetera. It would be, why would an Oklahoma court have authority, in other words, jurisdiction, to get her, to reach her and drag her to Oklahoma? So I want you to just remember this concept, what long arm statute means. Another word for that is a minimum contacts. So it's real easy. This is the way you're going to remember it. Just think about a court, and Amanda is not here in the state of Oklahoma, so they have to have a long arm to reach all the way to California to drag her back in this court. That's a long arm statute. For example, if Amanda, you don't need to know this for the test, but an example of things that Amanda might do that justify her being pulled into an Oklahoma court is selling into Oklahoma. She gets on Etsy and she sells things into Oklahoma, and they turn out to harm somebody, products liability. That would be an example of the a court might use the long arm statute to drag someone in from out of state. In other words, she's not local. All right. Okay. Again, there's a bunch of different ways to divide law, but I just want you to be familiar with the concept of what a tort is, okay, versus a contract, for example. So let's see, who else have we got here? Andrea. So Andrea, Andrea rents a car from me, okay, but she doesn't pay for it. And when she sees me on the sidewalk, she speeds up and runs over me, okay? Well, Andrea could be facing two types of lawsuits from me, presuming I survive. Number one is a contract she didn't pay as agreed by the contract. And number two, she did not agree, or she did the tort. She violated a right that I have by running over me. Okay, so look back on tort and just be generally remember that a tort is not a breach of a contract. That's a different thing. Okay. This one, I think it's important for you to understand, and I hate this ever since law school, because general damages and special damages, I think, are so confusingly named that they should be flipped, but it's been used for 100 years, so we're gonna have to keep following it. So basically, special damages, all right, Well, let's go back to general first. I wrote a few notes. So general damages are, she runs over me in a car. I guess the easiest way to remember is the damages I'm trying to get, the money I'm trying to get is so vague and so general. It's not specific per se to that. It's not like my medical fees and the cast I had to have and all that, but it's really general, pain and suffering, just, that'd be an instance of a general damages. But special damages, and again, this is the mnemonic, the way we're going to remember this. Special damages is, think of it as specific. So if I'm run over, then I can literally come up and say, hey, I can specifically show you, Judge, this was my doctor's bill, this is my surgery bill, this is the cast, here are my crutches. These are the damages that I can specifically write down and give you as evidence. So that's a special damages. Okay, so that's for monetary damages. Conversely, general damages might apply to non-monetary damages. So don't confuse those two, that concept. Okay. We already covered the difference between slandered and libel. They're both defamation. Slander, say, libel, written, newspaper, you write it on the internet, whatever. Next, remember that. Next, I want you, I'd written in my, I think I know I added it not only in the outline, but in my lecture. The textbook and most legal scholars differ a little bit about what it takes to have a valid contract. And some law school professors will say, oh, well, it's and then all these different defenses and really, I think it's important to recall three things. So this is what I want you to remember. To have a valid contract, in other words, what are the requirements? You have to have offer, acceptance, and consideration. Let's say that again. To have a valid contract, someone has to offer the contract terms, you have to accept the contract terms, and then there has to be consideration, which is just a fancy way of saying some sort of payment, something you pay or something you do. Let's say, for example, you're going to paint my car. That's consideration. Offer, acceptance, consideration. All right. Now, we're halfway through. We talked about the type of jurisdiction. I talked about personal jurisdiction. Remember, long-arm statute, it's over the person. I want you to remember that another way to remember another term for personal jurisdiction, which means jurisdiction over a specific person, or it can be a specific company, the company in California, person in California. There's a Latin term that's used just as much as personal jurisdiction. So the synonym for that is in personam jurisdiction, I-N, next word, P-E-R-S-O-N as in Nancy, A-M as in mother, in personam jurisdiction. Same thing as personal jurisdiction. So remember that term. Now, because it's so vague, you saw me kind of stumbling through on, well, how do we define the law? Or how do we divide it up and make it into categories? And you can do it this way, this way, or this way. For purposes of this test, I want you to remember two ways to characterize the law, what type of law we're talking about. Civil or criminal is one way, because you can divide everything into either civil or criminal. You don't have to know much more than that. You don't have to go what's civil, what's criminal, but just so you know for your personal and future reference, obviously civil is two individuals, companies, persons, etc., suing each other. Criminal involves the state prosecuting someone. So you can say it's either civil or criminal. They're not the same. Or you can say it's substantive or procedural. So whether we're talking about criminal or civil, the substantive law, you may recall, and again, you don't need to know all these details. I just want to remember the category names. The substantive may be something to the effect of Okay, the statute says I have to prove these things, blah, 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 blah. That's the law. But procedural is going to tell me what the procedure I'm going to have to do to get there. You have to go to court, you have to file, a complaint, you have to do this, you have to do that. That is the procedure to go to trial, for example. So 2 ways to categorize: civil criminal, substantive procedural. Both of those are ways to categorize types of law. Okay, let's go back to products liability. You may recall in your reading that there were a company or an individual could be sued in products liability / strict liability. Strict liability is another way to say product liability. Generally, there's exceptions to everything, but for this purpose, let's say that they're exactly the same. So this is the easy way to remember what we're about to talk about. If you're getting sued, you manufacture something and sell it on the market. There's 3 ways you can be sued for product liability, right? Let's just think about when the way you sell something on the marketplace. First thing you have to do is to R&D or design what you're selling, right? So let's say that we're selling a surgical instrument. So you egghead smarties, tech types, they get all together and we design this surgical instrument. Well, that's known as a design defect if we do that wrong. So you could be sued in product liability / strict liability for designing it incorrectly. Also, let's continue chronologically. Once we've designed it, we're going to manufacture it, right? Let's say we've designed it correctly, but somebody who's putting this together uses rusting, not stainless steel or something, and it rusts. And rust gets in the patient during surgery and gives them sepsis. Well, that is a manufacturing defect, okay? Now, let's say that when we sell this medical product, we don't say, hey, by the way, make sure you don't turn it, I can't even come up with it, make sure you don't do this, when you're in the body cavity, because it could kill them. Don't turn the laser on, out inside the cavity, it has to be out. I'm just making stuff up. That's known as a warning defect or failure to warn. So this is a specific thing I want you to remember. There are 3 ways that you could be sued in strict liability: design defect, manufacturing defect, and or warning defect. All right, let's move on. I don't really like the way the book is organized so much, but they jump off on intellectual property. That's fine. We just touch on it and then move on. But basically, intellectual property, let's think of property. If you live in a house or apartment, that's real property. You can see it, you can touch it, etc. Your chair in there is known as personal property, or the glass, that's also tangible property. Intellectual property is often here. It's something that's come about by the creative process. Okay, so that's known as intellectual property. Easy way to remember it. I thought about it. Well, so for example, if you're asked, well, this you don't need it. This is not to memorize right now yet, but intellectual, I just got some examples. Coca-Cola trademark, that's intellectual property. The Apple phone operating system, that would be a patent, something that's been patented. The Apple song on TV, or if I think it's Microsoft that has a special sound that they play, that's copyrighted. That specifically collection, that's a copyright. Each of those are intellectual property. So if you are asked about which things are types of intellectual property, if I asked patent, you would say yes, correct? But if I said, for example, contract rights, no, they didn't come about by someone's creative thought process. Land rights, property rights, no, they didn't come about by someone's property. Here's a trick question. What about whimsical musings? You've all seen the meme where the husband or the boyfriend, girlfriend, or whatever are in bed, and she's facing one way, he's facing this way, and she goes, "Oh, I wonder if he's thinking, all these deep thoughts or this or whatever." And he's saying, "Oh, I wonder why there are more hot dogs than there are hot dog buns in a pack." Just something really silly. Well, that's a whimsical musing. That is not protectable as a patent, for example. If you say you have a funny thought, yeah, that may be creative, but it's not legally called intellectual property because you can't get legal protection for it. Now, if you had that whimsical thought, but then you went on Netflix and had a 1 hour special, well, then it becomes copyright. But just a whimsical musing on your own, that's not in intellectual property because that's a term of art as a legal meaning. All right, next. I'd like you to remember there's so many issues of jurisdiction. What's jurisdiction? Well, one of the ways of thinking of a jurisdiction is the first court that hears your lawsuit has original jurisdiction. They're the first one to hear it. They heard it originally. If you appeal it, the appellate court has appellate jurisdiction. In other words, they can only hear this lawsuit if somebody appeals the trial court. So I want you to remember the concept of appellate jurisdiction. All right, next. Tort law, I'm going to let you look this up, but compensatory damages. I want you to remember that compensatory damages, there can be special damages and general damages. We already talked about what special are, and generally are general. But remember that both of those can be in tort law, special damages, general damages. All right, now, next concept. If I asked you, you might recall that we have intentional torts and non-intentional torts. Andrea or somebody, I don't remember, saw me and ran over me. Well, that's obviously intentional. If she honked before, she's assaulting me and battery because she scared me before and then ran over me. Then she stood over and screamed, it's intentional infliction of emotional distress. But if I asked you about negligence, would you say that that's an intentional tort? No, that is not an intentional tort. Negligence, again, let me say that again. Negligence is not intentional. It is not an intentional tort. All right. Now, I'd also like you to look over the defenses to negligence. In other words, someone sues you for negligence, look back through your book and find out what are the defenses. And I want you to remember that intent is not a defense. It's not relevant. Why? Because the plaintiff, whoever's suing, doesn't have to prove intent. It means quite the opposite. Andrea might, let's say she was just speeding and didn't even see me, but hit me, or she was looking at her phone and hit me. Well, that's a negligent act. She didn't mean to. So I would sue her for negligence, not for an intentional tort. That means intent is not a defense, nor is it an element of negligence. It's irrelevant to negligence. All right. Okay. I'd like you not just for the test, but in general, kind of review, okay, what happens in a lawsuit? Oh, somebody serves, somebody does this, it goes through. I want you to remember what discovery is, okay? I want you to look up discovery and then be able to recall what discovery is. That's in litigation. All right, real simple. The simple part is once we have litigation, Andrea sued me and I'm going to send her interrogatories, which are questions, or I'm going to depose her, or I'm going to send a request for documents or something. That's all called discovery. I'm discovering the evidence that she has. Finally, we talked about ambiguity in a contract where a judge can look outside the contract. So I want you to go ahead and look up and see when a court will consider a contract ambiguous. Let me say that again. Look up and be able to reiterate when a court, under what circumstances will a court say, hey, the contract's ambiguous, I've got to get evidence outside. All right, that is all the review I have. And if anybody has questions, now is the time. I'll wait for a couple of minutes, and I think everybody's muted. So if you do have a question, make sure you unmute. But failing that, it looks like no one does. I assure you, we have covered all the topics you need for the test. So I just will expect you to all be doing brilliantly.